Well, just going to straight into it, and one of the biggest arguments, at least from this end, that we saw was that argument between whether this election was constitutional and whether it was all about the numbers. I remember one of the people representing IEBC, was it Paul Mitchell, saying that nobody is challenging the numbers but the constitutionality of this election. From where you sit, what is it that were your biggest really highlights of all the arguments that were put across by NASA, IEBC and President Uhuru Kenyatta?
Well, I think a number of legal issues were canvassed. And regardless of the final judgment on this matter, I think the advocates for both the petitioners and the respondents really acquitted themselves very well. I mean, if you James Orengo, Otiende Amolo, Feroz Noroje, Muita himself, and Gatia. These people, I think these were the outstanding counsels who actually acquitted themselves very well. Now, the specific question that you've raised is one that it would be interesting to see how the judges will make a determination on that. And it emanates from an issue between an illegality and election illegality or election irregularities. In 2013, and one of the finest constitutional lawyers, Wachira Maina, has actually reflected on this issue and stated that in 2013, the Supreme Court judges confused an election that had substantial illegality and one that had substantial irregularities. And that was the essence, the discussion between the Section 83 of the Elections Act and Article 81 of the Constitution and Article 86 of the Constitution. And the view that was taken by the Supreme Court judge and the view that was constantly hammered by the lawyers for IEBC and President Uhuru Kenyatta is that if an election is illegal or that an illegality should not invalidate an election. And this is a confusion that election law jurisprudence has actually had. And in 2013, the Supreme Court actually confused and treated as one thing material illegality and material irregularity. Such that then but my position is this, that if the election is conducted and substantially in a manner that it violates the Constitution and the Elections Act, it's materially illegal and therefore should result to an invalidation. And secondly, if an election, and that is the essence of Article 1, Article 4, Article 38, Article 81, Article 86, and Article 138. Right. It was not deliberate. It was not mere statement of intent or elegant legal drafting that the drafters of our Constitution saw it wise to make that determination. Now, if an election is equally irregular, if there are numerous irregularities that goes at the heart of the final outcome of that election, it should be separated from an illegality, and similarly, it should result into an invalidation. Right. It's as simple as that. All right. Nelson,
what's your take on this one?
Now, the issue of numbers is very easy to debunk. It's not as complex as the people want to display it. Now, in mathematics, if you are facing a mathematical test, there is a question that will have 3 marks. What is the area of a rectangle? 3 marks. Now, if you give the area of the rectangle without indicating the formula of getting that area as being L times W, and you just arrive at an answer, you will get 1 for the answer, and you will lose 2 for the formula and application. It's as simple as that. Right. Now, we have a situation here where when called upon to explain, President Uhuru Kenyatta's advocates and IEBC say, no, don't worry about the formula. Don't worry about the application. We have the numbers. Look, that is turning logic over its head. It cannot happen. Let me give you another example. The test of invalidating election is very simple. 1, you have to establish whether the process conformed with what is set out under the law. Right. And 2, if it was performed under the process set out in the law, and there are irregularities, if taken in totality, abridge the number between the two candidates. Now, those two tests are separate and are supposed to be applied together. Let's now put it into the layman's term.
Right.
Make me a cup of tea with sugar and also serve it with githeri. And ensure that the number of beans and the number of maize in the githeri is equal. Now, you bring me a cup of tea. Instead of having put in sugar, you put in salt. It will not be tea. Now, you have interfered with the process, and there is no way of separating sugar from tea. So that process has become sterile.
All right.
So if that be the case, it doesn't matter the amount of salts you put in the sugar. It's no longer, it's no longer tea. Now, let's look at the githeri. If, before you start boiling the githeri, you've put a larger portion of maize as opposed to beans, I can say, okay, fine, stop it. Collect all the maize and separate. You understand? So that is one that the court can look at through a recount or a scrutiny and say, let's examine who really got the highest number of votes. Now, let's break down this case in the more simplified manner.
Right.
Raila's main challenge was this. The transmission of results was not done in the manner stipulated by the Constitution and as set out in the law. And his complaint was IBC had started projecting on the screen results that were not supported by any Form 34A or Form 34B. Now, how did this question receive an answer? The answer from IBC was this. Yes, the results you saw there were final results. And the question from the court was, where did you get those results? We got them from Form 34A. Now, at one point in time, your chairman said these are provisional results. Yes, the chairman was right, because by the time we went to this election, our system still had a dual transmission for provisional and the final results. If you were to ask me my legal opinion without anticipating the judgment, there is no way IBC could have said they served tea with sugar. That was tea served with salt. Let's go to the next step. Raila said that the irregularities in this election were so enormous that you cannot ascertain who was the winner. Now, what is the answer of IBC and the team by President Uhuru Kenyatta? They say, okay, fine. Look at the forms. Indicate to us. These ones had your agents. Look at the one in Nyali. Nyali was your stronghold. Even if you are to discount it, you will still, you will still have the numbers. But you see, it's not an issue of numbers. You understand? And then look at the system that is supposed to have ensured the sanctity of the results transmitted and declared. Raila's complaint was the Kenya Communications Authority had said, do not host your supplementary server outside the country, because if you do so, it has the capacity of being interfered with either intentionally or through sabotage. Now, what did the evidence disclose? First, the server was said to have been hosted in France. Then when they couldn't trust the people in France because allegedly they were asleep, they came back to court and made that statement. They said, okay, fine, we've woken them up, but the people in charge of controlling what they do have now moved about 10 longitudes this other side. They are in the United States of America. And then eventually, when the read-only was supposed to be effectuated, it was denied. And the perfunctory entry that was given to investigate this server disclosed for a fact that it had been breached from outside. You understand? All right. And if this system was supposed to be tamper-proof, I think it is easy to see, without any legal intervention or any legal discussion, how flawed that process is. All right. And then you can see there were many other intruders into the system who appeared either to be loading, deleting, who were not authorized. All right. We'll
get to that audit report shortly, but Felix, you wanted to add something in regards to that?
Actually, yeah, just to support what my learned colleague is saying. I mean, it's in law, it's in election dispute resolution. It's called jurisdictional competence. If the law prescribes that in order to arrive at decision Y, you must, first of all, resolve decision X. Then you cannot purport to arrive at Y without dealing with X. That is exactly what Nelson Harvey has described. Sometimes back during the Grand Coalition government, The law prescribed that President Kibaki, for example, could only make a decision in consultation with the Prime Minister. Now, there were a number of instances when Kibaki overrode that and made a decision, which the court then came back and said, this is irregular. This invalidated that decision. The IEBC cannot arrive at the results at the National Tallying Center without complying with the constitutional requirements of Forms 34As and Forms 34B. And let me also just be given that some of the issues that came up, that especially are issues of the law that we really, really need to set into perspective. And it was repeated yesterday by the Honorable Attorney General, whom I respect a great deal. And when he appeared, we appeared with him before the Senate hearing in early this year, over the amendments that were on the Elections Act that were being proposed. Now, the Attorney General, during the Senate hearing and yesterday, gave a completely misleading discussion on that our constitutional and legal architecture for elections is manual and complemented by electronic gadget. Now, that is a pre-2010 thinking. The truth of the matter is that our constitutional and legal architecture for results transmission is electronic. There is no any other way to explain it.
Right. Interesting. Yes. And I want us to get into the audit report. It was one that really raised temperatures yesterday evening, in court. Of course, all the sides giving what, would favor them most. And of course, James Orengo came out to say that there were quite a number of issues that they saw, forms that did not have signatures or watermarks or security detail or what do you call it, the security features on
numbers,
them.
Watermarks, etc.
Exactly. Yeah. And of course, on the other side, Fred Ngati also came up with his own argument, and so did Paul Mwite. What is going to be the role of this audit report? Does it have a major role in the discussion and in the of course, the final decision that we'll have from the Supreme Court? Javi, what do you think about that audit report?
Now, the audit report was submitted pursuant to a directive by the court that go and scrutinize. And let's ask ourselves, for what purpose were we supposed to go and scrutinize? The scrutiny was sought on the representation by Raila that what IBC did was to project results fast, declare a winner, when about 3.5 million worthy of votes in respect of Form 34A and 34B had not arrived at the National Tallying Center. In fact, if you are to follow that analogy to its conclusion, it says you declared the winner first and then you proceeded to collect the Forms 34A and 34B last. Now, you remember, and some of those lawyers who appear to be in the Supreme Court with gowns to shield them from the cold instead of understanding what was happening, still claim they did not see the bombshell. The bombshell was there. It is as simple as this.
What was the bombshell?
What IBC forwarded to the court as Form 34 and Form 34B were not the documents that were printed by Al Ghuraya. These were documents that were created much later to sanitize the results that were being projected. And the best way to interrogate that fact is simple. The scrutiny enabled the entire team to do a backward read on the security feature on each of these forms. And it indicated that these were not forms that tally with a particular polling station or with a constituency. Now, some of the forms did not have a serial number. And look at the manner in which that issue was addressed by the lawyers for the IBC. They said, fine, there was no requirement on our part to have a serial number or to have a barcode number in these forms. Then the subsequent question was, then why did you have the serial number and the barcode on some forms and not others? It was out of caution. Look, such an explanation cannot find comfort in anybody with logical thinking. Because, you see, these forms are designed to be similar. So to speak, they are made on a stencil. And the only differentiating factor will be the sequence of the serial number. So that if you are to make them, you will be making them out of a duplicator, like this, like this. And then the only difference will be, this will be different from this and that, because of the flow of the serial numbers.
Right.
Now, it's like you've paginated a book from page 1 to page 50. And then you ask somebody, deal with the book. When the book comes, page 45 doesn't have the page. That is the best way of indicating manipulation.
Okay.
And that was the bombshell.
Right.
And the results that were affected by this bombshell, if you are to follow that argument with its logical conclusion, turned out to be more than 7 million. And then if that is the yardstick upon which this election is challenged, then you can see the balance of the evidence really indicate that something drastically wrong took place in this transmission.
All right, Felix, before I get your thoughts on that, just to bring you up to speed with what's happening on the other side of the split screen, bodyguard attached to NASA Principal Moses Wetangula is in court, as you can see. He will be charged for causing disturbance at the Supreme Court. Constable Simon Lonyang, who served at the General Service Unit, was disarmed and arrested after a bitter confrontation with the Central Police Chief Robinson Thuku, who tried to restrict him from entering the court compound with a pistol, contrary to no arms beyond this point posted out was at the Supreme Court. Lonyang was on Tuesday morning taken to the GSU headquarters where the disciplinary proceedings started. Deputy Inspector General of Police Joel Kitili last evening insisted that the officer had not been fired and those disciplinary proceedings were yet to end. So that's what's happening at the Milimani Law Courts on the other side of the screen, and really we'll be following up on that. Remember that Moses Wetangula has come out to say that indeed if this officer is going to be fired, he will indeed move to court to really resist that. So we'll be following up on that particular case there. Felix, coming back to you on that issue to do really with the impact of this audit report about the servers and poll materials from IEBC. What's going to be the weight of this in the final determination?
Well, I think it will be weighty. In terms of evidential threshold, it will be extremely weighty. It reminds me of what happened during the Watergate scandal that led to the impeachment process and the resignation of President Richard Nixon in the United States. The clarion call then was, in order to establish the transgressions that had been conducted by the Republican Party and President Nixon in particular, was that follow the money. And as soon as this election was concluded, I posted that to establish the truth, follow the technology. And I was vindicated when I saw the report by the registrar on some of the things that were found during the IBC's, in the IBC's technology or the KIMS as it is.
Right.
The first question, of course, would be why was the reluctance by the Commission to be able to fully allow and comply with the court order, and the excuses and shifting of goalposts and things like that. The truth of the matter is technology, especially the election technology, leaves footprints, and you cannot actually erase or delete and do away with it fully. And both sides of the divide, the petitioners and the respondents, of course, were trying to gain access to, to make arguments for and against, or arguments that were beneficial for their cause. But look at as prescribed by in the elections amendment by the Kiraitu Orlengo-led bipartisan parliamentary committee. Why it was integrated first was to ingrain, and that's why it's called KIMS, was to ingrain substantial security features in this docket, in this the KIMS system. And as IBC through Msando went repeatedly to indicate that the security features of this technology was so foolproof that it was, one, known only to very few people, but secondly was insulated from external interference. Now, the sheer volume of interference, the sheer volumes of manipulating the statutory forms 34 and things like that, and if you add that to the reluctance by the IBC to allow this system and to comply with the court order, and if you look at the number of playing around with figures and the deletion, first of all, the deletion within the time frame of when this election was conducted and when the results was announced, and immediately thereafter, until yesterday, there is something first, they can only lead to the conclusion that the technology as prescribed by in the Elections Amendment and the regulations on technology did not comply with what was there in the law.
Right.
Now, secondly, there is evidence, more than ample evidence, that the substantial interference was done to the system.
All right.
Yeah.
Gentlemen, we'll have to wrap up, but I also want us to delve deeper into the issue that we only had 6 judges yesterday, present at the court. Mohammed Ibrahim was taken ill. What kind of impact will this have? Because it creates a situation where we have an even number, and that's really not how ideally it should be. So Nelson, first of all, I mean, he wasn't there during the Uhuru Kenyatta's submission together with the amicus. Are we likely to see this have an impact, in the judgment, and how will they go about it? Will he be there to also give his thoughts, of course putting into consideration that he was not there for a very crucial day of the proceedings?
Now, ideally, under the Constitution and the rules, the Supreme Court is supposed to sit in an odd number. And in a case of this magnitude, it has to be a minimum of 5 and a maximum of 7. Now, the hearing commenced with the sitting of Justice Mohammed Ibrahim, but
yes,
unfortunately was taken ill in the process. So it cannot be said that the Supreme Court was not properly constituted, because the manner in which he was not able to sit yesterday was what we call an act of God. It was not his doing.
Right.
But is there a handicap in a decision being made? In my opinion, I do not see a handicap, because the Supreme Court is a court of record. It's the only court that has a Hansard, so that the proceedings are transcribed real time. So all that will happen will be when the judges are retiring to consider the evidence and the law, what Justice Ibrahim will have to do is just to reference the key points that emanate out of the Hansard, and if need be, then he can be consulted. And should there be a caucus, a conferencing, or a need to take a vote, he will, of necessity, take a vote.
Right.
I do not see any handicap.
Your final thoughts on this, and especially what to expect before I come to Felix Tum. We have only a few hours as we wait that determination. What are you expecting from the court as a Kenyan and also somebody in the practice?
Well, as a legal practitioner, I expect the court to make a decision based on evidence and the law. If the court comes to the conclusion, based on evidence and the law, that this petition is not meritorious and is for dismissal, then as a lawyer and as a Kenyan, I'll accept that decision. And I'll also ask all Kenyans to accept that decision. If the court comes to the conclusion that the petition is merited and therefore we have to invalidate the election of President Uhuru Kenyatta, then so be it. It must be taken to its logical conclusion. But let's remember one thing. Why are we here? We are here because there is a desire to have truth and justice in the electoral process. My opinion is, even if this election of President Uhuru Kenyatta is invalidated, that will not be the solution to the problem. If there is impropriety, and I think it is a matter of public notoriety that there is evidence of impropriety on the part of the IEBC, then more than what happened to the Isaac Hassan-led commission should happen now. These people should not be sent home on a package. They need to be prosecuted. A signal has to be passed to those in the public service that you cannot defile the will of the people. Steal other things, but don't steal the popular will of the Kenyan Mwananchi. So that way forward, and I do not speak for Raila, but it's a matter of public notoriety. I'm his supporter. But the thing is this, Raila said, I want to use this court process to demonstrate to Kenyans what adheres to what is just. And it's only that you can attain peace.
All right. Felix, your final thoughts and your expectations
I
for
fully agree with my learned colleague Nelson. And the truth of the matter is that if any of the three of us make a mistake, it is personal to us. It will probably affect our immediate family, but ends at that. And I've told Ezra Chilaba this several times. The difference with IEBC as a constitutional commission, first of all, because of the sovereignty of the people, and people exercise their sovereignty through elections, and the facilitators of that election are IEBC. What it means is that it elevates the IEBC over and above every other constitutional commission. Now, if IEBC makes a mistake, people die. as was evidence in 2007, and quite recently as was evidence in this election.
Yes.
People, that's the difference. When you make and I make a mistake, it's personal to us. When they make a mistake, people die. Secondly, when they make a mistake, it usurps the sovereign right of the citizen. And Article 1 of the Constitution is absolutely important on that. I have all full confidence that the Supreme Court judges will render justice, will consider the evidence and things like that, and that is a purview of them to be able to do that. And without offending the sub judice rule, I stated this even before this election,
yes,
and confirmed it immediately after this election, that if you look at the way this election was conducted, it is the most shambolic in our history. More shambolic than even the 1988 elections. For this reason, one, in 1988, President Moi, as he was then, never made any pretense of holding elections that was credible. Elections in 1988 were conducted by the district and the provincial administration. And in 2013, we have the 2010 Constitution that introduces a normative framework and standards for holding elections. Number two is that never in our history have we committed so much substantial resources to an election than what IEBC has. IEBC was given exactly what they wanted. Now you cannot therefore say that, oh, that was a minor mistake, a clerical error was conducted by a returning officer.
Right.
Our laws have shifted since the Maina Kiai case, and that is